morning. Please be seated. This is the time set for oral argument in the matter of Salmons versus Key, our civil number 14-0475. Each side will have 20 minutes within which to present their arguments. This morning, appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. As you're making your arguments, understand, please, that we've read the briefs, we've been through the record, we've conferenced this case, so we have a pretty good understanding of the factual and procedural background. We are recording the proceedings here this morning, both by audio and video tape. So for those of you who would like to listen or view the recording, you can do so by going to YouTube in a few weeks. But in any event, for our purposes, as you approach the podium, please identify yourself and your client for us so we can keep track of that. And with that, petitioner may proceed.
Good morning. May it please the court, my name is Mark Shields. I represent the appellant Beverly Salmons. What we have here today is a case that I think is in some significant respects a little different from a case that this court would typically encounter, at least from the appellant's perspective. Here we have an appellant who is actually not challenging, for the most part, any factual findings. To the contrary, what we are doing is looking at some straightforward findings and then putting them into the context that makes it right for this court's decision to reverse and remand. Specifically, we have a factual finding made very clear in the ruling on our motion for new trial that the business at issue is worth $190,000 at a fair market value or $240,000 at a fair value. That's a finding. That's what the business is worth. That is not being appealed. Along with that, on the other issue before this court, we have factual findings under ARS 25324 that both parties had engaged in some degree of unreasonable conduct under one of the statutory prongs, and also, more significantly, that there is a large disparity in financial resources, husband having far greater resources. Factual findings, again, not challenged on appeal. Those findings led to a ruling in the initial decree that wife was entitled to an award of fees under 25324. What brings us here today is the fact that the judge did not pay any credence to her own finding of the business's value, and that she somehow reversed her conclusion that wife was entitled to an award of fees and she did so on grounds that are not legally proper. That's what brings us here today.
So on the first issue, you're asking us to remand, tell the court to award the property to husband?
Yes.
And impose a lien of $120,000 on it?
Correct. Thank you for clarifying that, because those questions that you just asked, Judge Kessler, go largely to what was argued in the answering brief. The answering brief is full of arguments that say, oh, the business really isn't worth this, the business really isn't worth that. It's all comprised of goodwill, as if to argue that goodwill is not a divisible asset when it clearly is. Those arguments miss the point, because we have a factual finding that the value of the business is worth between $190,000 and $240,000.
Oh, counsel, can I ask you a question about that? Let's assume that we agreed with you and decided this case should be remanded for consideration of that order. Wouldn't the trial court have to have a hearing to determine what the current value of the business is, whether it has changed or not?
We value the business at the time of the the termination of the community, and that's what the business valuation was based on. Frankly, we had arguments that the value of the business had increased, and I think it was clear that the business value had increased because business was picking up, but we are in fact to value it as the time of the termination of the community. I'd like to point the court on that issue to pages 17 and pages 18 of the answering brief. Now, these arguments, again, miss the point, but they show the legal error in the trial court's ruling. The middle of page 17, there's a statement, if the appellant was awarded an equalization of the maximum set forth by the appraiser, appellee would be forced to work well beyond what he articulated he planned to do otherwise, as testified to clearly by the appraiser, and so on. That is an if, that's a hypothetical that shows the legal error that's involved here. If she were given half of what the court found, it would change everything. Well, the court made its finding, and that finding is not on appeal. That shows, again, the legal error that we're dealing with here from the perspective of husband. Turning the page to page 18. If Mr. Kege sells the business, appellant will get half the proceeds. If, well, what was ordered was a sale. Here's why that matters. With the adjudicated value of the business, 190 or 240, 190, the fair market value is meant to apply if it's being sold to a third party. The fair value is meant to apply if it is kept within the current ownership. But with these two ranges, the trial court on that finding essentially gives the court two choices on how to actually divide the asset. Instead, what we have is the trial court choosing option C. It doesn't fit. More specifically, I would concede that the trial court actually chose option C or D. Now, option C would be selling the property to the son. This is why I laid this foundation with the arguments on page 17 and 18 of the answering brief. This is not proper. The value was discounted to a sale to the son. The evidence is clear. The evidence is undisputed that the son has no intention of buying it for anywhere near that amount. This simply is not supported by any law. There is no law saying we can discount the sale if it's to a certain property or a certain other party. That may benefit the buyer, though there's no question it would benefit the buyer, but that's not the court's duty under 25.318. The court's duty is to divide the asset.
Counsel, let me ask you, with respect to the two valuations you've mentioned, the 240 and the 190.
Yes.
Those are gross values, correct? Not
Correct.
Net of cost of sale?
There's no evidence in the record that addresses cost of sale. I do think it's the only assumption we can make under the evidence is that is something the valuator took into account, and that's why we have the 190 versus the 240, because there would be a lesser value if it is actually sold to another party.
Although the 190 also contemplated some transition, right?
Correct.
And with respect to Judge Winthrop's question, you indicated, look, all we need to do is to, or perhaps it was Judge Kessler, to affirm and direct the Superior Court to impose a lien of $120,000. That assumes that the 240 is a net number and assumes that that's the right number, as opposed to even you sort of concede that 190 is in the mix there. I mean, I know you object to 150, but why is 120 the value of a lien, the only value?
Actually, Judge, your question emphasizes my point, and that is that the trial court had two choices. If for whatever reason it had chosen the 190 or the 240, either one of them would be correct, because there's a finding that the value is somewhere in there. But instead of doing that, the trial court went completely outside the paradigm, gave a discounted value to someone, and the court's rationale for doing that.
Let me interrupt you. I understand that, and I understand that you don't like the 150 number and you believe that that's error. But if we agree with you, it seems to me that it's more than simply picking 240 and therefore remanding for a lien of 120. Isn't there more work to be done, even under your situation in front of the
I
trial
will
court?
concede that that is a remedy this court could grant, that it could remand for further proceedings to determine which of those two amounts is more applicable. The argument is there implicitly. The argument was raised for the higher number, but I will concede that the court could remand for either consideration. Again, what we're dealing, though, between A and B ends up between C and D. One note on the 150 that you mentioned, Judge Thuman, selling the business to the son. She made a specific finding that would be better for the family if it proceeded that way. Now that is a statement that puzzles me. I might even call it bizarre. We don't divide assets on a best interest standard for the family. We got 318 confused with 403 in a divorce court. That gives the court an idea of the paradigm that was going on, the paradigm within which this property was divided, and it shows that it's wrong. Now, with respect to the sale to a son, again, this is where we get into evidence. This is more of an abuse of discretion rather than a straight de novo legal conclusion. But the evidence was undisputed that the son did not want to buy it for anywhere near that money, that the husband didn't have any intent on continuing to work and to cooperate with the sale in any way. So that leaves us with a sale that was ordered, but an asset, as we argued, that is completely within the control of the husband. That he's free to do absolutely nothing with it, including, most specifically, never sell it. Now, this order was entered close to a year and a half ago to begin the sales process. Conceded throughout their answering brief is that has not happened, that this property has not been divided. That leaves it at husband's sole discretion. Wife never gets her interest. The fact that there's no deadline for sale brings this case squarely within another case. I apologize. I acknowledge that this case was not cited in either of the briefs, but it's important, I believe, for the court to look at. That case is Hardin v. Hardin, 163 Arizona 501, 788 Pacific 2nd, 1252. It's a 1990 case, I believe, from this division. In that case, an asset was awarded completely to one spouse with a lien placed on that asset, as we are requesting, but there was no deadline. And because of that, the court held, the trial court left the asset completely with one spouse, and that deprives the other spouse of an actual interest on it. That rationale rests on Kelsch v. Kelsch, in which the court held that dividing an asset under 25318 is meant to give each party a vested, current, real, tangible interest in property. We have none of the above in this case because of this ruling.
I understand that, but how can you set a deadline for a sale? It's either sells or it doesn't sell. I guess you could say wife could sell it.
Well, again, the interesting point is we really don't even get to this question if we just divide the asset as 318 says to do. But beyond that, we at least have to have a deadline for efforts to sell it, to put it on the market, and we have nothing of
I mean,
that.
that's something within the discretion of the trial court to decide how it should be sold. Either party, technically, I assume either party could sell it.
And again, that actually emphasizes our same point, I think. I'll point the court to page 18 of the response brief, where husband says if he sells it. Well, there should be no if involved. It's what was ordered, and that shows the court the problematic nature of what we're dealing with here. It's a situation in which wife will never realistically receive her asset. I need to move so that I do save some time for rebuttal here to the fee issue. Again, we have a finding. That finding, that determination that wife was entitled to an award of fees is actually certified under Rule 78B. It'll always be 54B to me. It takes a while for my brain, even with all these years of family law rules.
The decree uses 78B.
Correct.
And says she'll get fees.
Correct.
And then we have an order, and I think it's unsigned, on the award. Is that right? It's unsigned order on the award of fees saying she's not getting anything.
Correct. And I apologize. I don't know if it's unsigned or not, but I apologize. Continue.
It's unsigned. And I think we have a question about whether we have jurisdiction over the fee issue. And I'll tell you that because we have a 54B or 78B decree, we felt that rather than delay the oral, at least I think we were thinking, rather than delay the oral argument on this, is to hear the arguments. It's been briefed, it's been fully briefed, and we might, and I'd like to get your reaction to this, we might suspend the appeal briefly after the oral arguments to have the trial court, to have you apply for a signed order on the fees with a short deadline, take your amended notice of appeal, and then we would just, without further briefing, we would decide the fee issue.
If the order is unsigned, you're quite prescient. That's exactly what I would request, and I would appreciate that.
Go ahead.
What we still have, though, is a determination that she's entitled to fees, a portion of fees. Well, 0 is not a portion. 0 is a
But didn't the
numerator
trial-
that doesn't work.
Didn't the trial court actually calculate that, that your client used community funds to pay the fees?
The decree actually states that both parties used community funds, and frankly, I don't understand the relevance of that, because the legislature in drafting 25-324 directs the trial court to look at the financial resources of the parties. That's much broader than simply the community property available to each party.
But if one spouse has used a, lack of a better word, disproportionate amount of community funds to pay fees, that's not something the trial court can take into consideration?
I think that's reading something into 25-324 that the legislature did not put there, because the legislature is making it a much broader field to consider. The fact is that if the party with the far greater financial resources were contributing as is intended and as was determined in the trial court, there would be more community property to divide. And that's an issue that we can't find any reported case law directly on, but I think it's clear because we're looking at the plain language of a statute that goes far beyond the community property available to each party, especially considering the case law we've cited that shows that the purpose of the statute is to provide a remedy to the party least able to pay those fees, which, as the trial court found, is clearly the wife. I'd like to reserve the remainder of my time. Thanks.
Good morning. May it please the court and counsel. The two issues, of course, disposition of the business. Secondly, the issue of attorney's fees. The standard of review, I believe, would be an abuse of discretion by the trial court. In this particular case, as far as the business is concerned, the options before the court based upon the facts were very limited, and the court did the best it could under the circumstances and the facts before the court to dispose of this property and divide it. The court obligation under the statute 25-318 is to divide the property equitably. And usually when there are many assets, such as community fund assets, one asset may be allocated to the other as an equalization payment to award the property to the one of the properties to the other. The court found that there is no basis or no source of equalization payment in this particular case. There was nothing to offset an equalization payment to wife. And under those circumstances, what option did the judge have? Well, the options were, number one, award the property or the business to wife who was not capable of running the business. She had health problems. She was not intricately involved in the business other than doing some bookkeeping work, or award it to husband. In this particular case, husband is 66 years old. He has health problems on the record that was set forth before the court. He wants to retire. He doesn't want to be any further stressed in this business. and he's not interested in buying the business or continuing the business, even though he has done so up to this point because of the nature of the appeal. So when you have an asset before the court, that when the judge has to divide it equitably, and there's no offset available, the only option I believe the court would have is to order it sold, and that's what the court did in this particular case, and I don't think she abused her discretion in ordering that. I think it was in accordance with ARS 25318, and she ordered it sold and the parties divided equally. Now, the problematic case part of this is, okay, let's sell it. The issue is not necessarily if it would sell for the appraised value that the expert came up with. It's really who's going to buy it. Is there going to be an arm's length transaction between a buyer and a seller, and is sold at the fair market value? It's like any other asset. You try to get the best you can for it. So given those options, I believe the court did the best it could under the circumstances with what it had to work with, and did follow the statute as far as ordering it sold and equitably divided. Now, this issue of lien, didn't come up during trial. It was never asked for. I'm not sure what is proposed. It was not proposed until later on in a motion for a new trial filed by a wife. But what, a lien on what? If a lien is imposed on the business, well, we all already concede wife is entitled to 1/2 of whatever the business is worth or what it can sell for. So a lien...
Is that the proper valuation term, or is it the date of the valuation of the date of the decree? In other words, let's say in a rising market or a falling market, isn't it the time of the decree that's really the valuation, and what happens kind of later, it doesn't affect that valuation?
That's a good question. Typically, I agree that it would be at the time of the decree, because that's when the evaluation, that's when the court took in consideration the valuation by the expert. Yeah.
Right, and the reason for my question is it may be that if that valuation is accepted and then wife has a right to half of those of that value. One answer might be we don't care what it sells for later. It's just it needs to be sold in a given time, and she has a claim to X amount. And your opponent has said that X should be anywhere from $95,000 to $120,000, and I'm guessing you have a somewhat different approach on that, and that's fair. But why, the subsequent events, the months after, what husband intends to do or not with the business, why is that relevant to that valuation and the appropriate lien on that valuation date?
Well, as far as his desire to retire,
for example.
Okay. Well, how is he going to fund that? How is that? Where we're going to get that money to give her $120,000 or whatever?
I don't know, but if the valuation is as of that date, and presuming that's a solid valuation, and that's really not challenged on appeal, at least I don't see the valuation being challenged. No. As long as the proceeds cover that, whatever the appropriate lien number is, couldn't wife effectively say, I don't care, I'm entitled to the lien amount?
If it sold for less than the lien?
Then she cares. But let's assume that the net sale is let's say the proper lien amount, hypothetically, and I know you don't agree, is $120,000, and it sells for $121,000 net. Her lien satisfied, she's happy. Issue resolved.
Well, if she's, I guess conceivably, yes, you're correct. But that's in a vacuum because it's not going to sell for that.
And
mean,
I understand that, and I think everybody wants for it to sell a whole bunch more than that, I think.
Yeah.
But in other words, we focus some, and the briefs focus some on what happens after that date, and my question is why should we focus on appeal about that? Isn't it really the question is, what's the appropriate lien or interest as of that valuation date?
Well, I disagree with the fact of the lien aspect of this thing. They never asked for it. It was never presented to the court as an option. The court didn't even consider that.
What's the purpose then of valuing the company as of the date of the decree?
Well, if it could sell it, it depends on whether the valuation is to set forth what each party is entitled to. Okay, so if it could be sold for that, or it could be funded, that's what should be done. But it couldn't be funded. There was no offsetting asset. So what do you do with an asset when you can't fund the one half to the other party? The court's option would order it sold, equitably divided. There was no lien imposed. There was no lien requested. So I think the order of the court was properly entered that sell it and equitably divide, or equally in this particular
And
case.
how did the court come up with $150,000? I mean, if it would be one thing if the court said, there's nothing else that can cover this, and therefore sell it at whatever, and I'll decide if that's a fair price. I mean, if the husband tries to sell it, if your client tries to sell it and tries to sell it at a vast discount, I assume the court could step in and try to stop this, stop the sale, saying it's a waste of an asset. But how'd the court come up with $150,000?
Well,
Other than saying it's in the best interest of the family?
other than she felt that if husband and son were interested in purchasing it, she would put $150,000 value.
But what if the
On-
son, but
pardon?
there isn't any evidence the son was willing to do that.
That's correct.
So how did she come up with $150,000?
Well, I think she was hoping that might be the case, but she discounted it because of selling costs
That's
and
good
so on.
enough for the valuation?
But
If the court hopes that it might encourage a sale by someone who doesn't want to buy it, that's valid? That's
well,
And it's
she didn't
description.
order it to be sold to a third person at a discount. She just was indicating that if husband and son were interested in, to avoid the cost of selling it, she would discount it to them. And ARS 25318 does allow some obligations to be taken into consideration by the court.
Well, counsel, was there anything in the record to support a cost of sale deduction?
No.
So we don't have any idea what the discount to 150 really represents, whether it's a cost of sale deduction of some amount. I mean,
You're right.
Can you illuminate any of that?
You're right, but I think it's a moot issue because it was indicated that neither the son or the father wanted to purchase the business. Father wants to move on. He's ill. He's got health problems. He's 66 years old. Do you require him to continue to work past those issues? There was an offer to give it to mother. The wife, she could have it. But given the circumstances, there's no way she could run it unless she hired somebody to do it. So I don't think the option that the judge chose in this case was an abuse of discretion. If I can move on to the attorney fee issue, and I'll be short on that. Again, that's an issue of discretion. the court found, well, first of all, the majority of the case dealt with husband's VA benefits. From the very beginning, those VA benefits were obviously exempt. Those are his sole and separate assets. Time and time again during this litigation, wife raised that issue, litigated it completely. The trial almost took 75% of the time. That wife was claiming 1/2 of that as her share of those funds, when it was clear, the statutes are clear. The federal statute, there's federal case law, there is Arizona case law, that those funds are the veterans' combat-related benefits. And they're exempt. They can't garnish it, you can't do anything. So there was an awful lot of time devoted to that issue when it was very clear to the court and to everybody else that it was husband's sole and separate property. The reason I bring that up is that you'll notice in their appeal, they gave up on that issue. They didn't even try to even convince this court otherwise. So the court ordered attorney that husband pay a portion of wife's attorney's fees, subject to application by wife indicating that what was paid from community funds and what was paid from her sole and separate assets. And the court found, after it was briefed, that the majority of wife's attorney's fees were paid from community funds. In fact, the record will indicate she took a lot of money out of the business account. She was on those business accounts, took those monies, paid her attorneys. So what she essentially was doing is taking husband's 1/2 and paying her attorney's fees and costs. And I believe that's why the court ordered that she had already received, she already paid about $50,000 or $60,000 to her attorney, and a lot of those funds came from community funds, of which husband was entitled to 1/2. So husband paid a portion of her attorney's fees, and I believe that's what the court ruled on.
Counsel, given your argument on the fees, you heard Judge Kessler express concerns about jurisdiction and a process perhaps to resolve our concerns. I assume you have no objection to that process.
I'm not sure I understand that process.
Sure, and I'll let Judge Kessler speak for himself, but I believe the suggestion was we've received briefing on the attorney's fees issue. If, in fact, the fees awarded or the Superior Court's order addressing those was an unsigned minute entry, concern we have is whether that's an appealable order that's been appealed to us. The suggestion was perhaps if the record confirms that, to stay the appeal for a brief period of time to allow the parties to secure a 78B order with respect to the attorney's fees, file a supplemental notice of appeal, and revest this court with jurisdiction. In other words, to avoid sort of serial one appeal after the other. I assume your client has no interest in a subsequent appeal on the same issue that you've briefed already.
Correct.
Okay.
But I don't know what we're going to accomplish. It was appellant's obligation, in my opinion, if it was an unsigned and they were wanting to appeal that issue, they should have had that issue brought up with the judge.
If in fact that hasn't occurred, it could occur in the future absent the stay. In other words, if it was not an appealable order, it seems to me that there'd be two options. One is the stay that Judge Kessler had suggested, and another would be to just drop it and let that appeal come separately in a subsequent appeal, which again doesn't seem to make a great deal of sense for all involved. And I wanted your thoughts on that.
Okay. Well, you're not talking about remanding to the trial court. You're talking about briefing that issue here.
Let me now defer to Judge Kessler, having pressed it with respect to the proposal.
Generally, we need a signed order,
Correct.
and we have a 78B decree. which means the decree is final. It's appealable under 78B, but then the attorney's fees award, I don't think is signed. So we wouldn't have jurisdiction over the attorney's fees award until it was signed. Rather than asking for briefing on that, our thinking was simply the merits of the attorney's fees issue has been fully briefed. Remand it to have parties get a signed order, file an amended notice of appeal, and we will decide both issues in one decision without any further briefing.
Okay, that's fair. I got you. All right,
We thought it was a practical approach. Okay.
all right.
So I
Thank you
take
for
it
your
your
time.
argument on the merits and the attorney's fees, if I remember understanding you, is the judge looked at it and said, well, what's the reasonable amount of attorney's fees since wife used some community assets to pay her portions of her attorney's fees? She doesn't get any more. Is that what your argument is?
Basically, husband already paid out of his share of the community funds her attorney's fees. And in considering that the background is that she took that money, the disability fund, he got a lump sum, she took that money and absconded with it. We had to go back to court, order her to return the money, and he even had to go to court for contempt to get that money. And then I believe there's the issue on attorney's fees on appeal. This court recognized that they failed to file a transcript in this case.
But you did have a transcript, didn't you, when you
I
filed your
finally
answering
got
brief?
it, yes. I couldn't figure out if they were just appealing without a transcript, which I've seen happen.
But you did have a copy of the transcript when you had your answering brief?
Yes.
before you filed your
Amended,
answering
we had
brief.
to file an amended brief.
I understand that.
Yeah.
When you filed your original brief, did you have a transcript?
No.
Okay, so
No,
you
it
only
was
got it
never-
afterwards.
Yeah, it wasn't until a week before the previous oral argument set by this court.
Okay.
All right, thank you.
Thank you. I apologize for being a little quick in there. One of the first sentences Mr. Hurley spoke had to do with an equitable division. Now, that is the law. In this case, equitable was defined by a factual finding of either $190,000 or $240,000. Again, the result we're left with is something in all likelihood very different. Yes, there is a possibility it might sell for that. The way things are now, in this state of the record, there is no possibility of that because there is no sale. There's no sale that's been attempted, and there's no sale that is in the works by everything we've heard today. Mr. Hurley, I don't know if he realized he said this, but he said, if it is sold, she'll get half of that value. We don't deal with ifs when it comes to valuations. 25318 imposes an obligation on the trial court that takes the hypotheticals away. If it's sold, no, we divide the asset. It really is that simple. And if it's sold, and if that amount is anything different, she'll get half of that. That does not fit. That does not harmonize with what was ordered or what was found, again, being that 190 to 240. Now, there's also some discussion here that I think misses a reality. Mr. Hurley claims, as the trial court found, that there's no community property from which half of the value of the business can be paid. That's not accurate. There is a valuation of that business. That business has inherent equity. That's why the valuation was done. Judge Thuma, you said presuming it's a solid valuation. We have to presume that because it's the record. It's what we take here on this court. It's what we work with. And that valuation shows inherent equity and goodwill in accounts receivable, in hard assets, and so on. Whenever we have a case in the trial court where we have to divide an asset and one party ends up with that asset, where does the equity come from? It's simple. It's obvious. We all know this. We've all done it when we've bought a house, presumably. We take out loans. That's why it's called a home equity loan. We're tapping the equity. We're tapping that value. That value is there. That value can be paid. Now, anytime value is paid, it comes from sole and separate property if it's after a divorce. And Well, the record is very clear that he has hundreds of thousands of dollars of sole and separate property as well, if he chose to tap that. In fact, even 25318E, when it talks of putting a lien on separate property, it's formerly community property, but it's still separate property. The legislature has made it clear that separate property is available if needed to satisfy
So you're saying
to
the
affect
court
a-
could order, whether it sells or not, could order to satisfy the lien, could order a husband to pay it, and doesn't care where
That's
the money comes from.
that's
It could come
exactly
from
right.
Any separate property he has.
That's exactly right, because that's how we divide assets. You know, if a business is being divided, I can tell you from my own experience, I know what happens. The party keeping the business has to go out and get a loan. It's as simple, it's just the way it is. But we do it all the time, and nowhere have I ever heard, aside from this case, an argument accepted that, oh, there isn't really enough property, so let's just not divide it. That completely defeats the purpose of the statute.
So technically, what you'd really want on remand, if we agreed with you, was to remand, vacate the decision about the order of stuff, 150,000, say that it's either 190 or 240, and set a date by which husband has to pay her that amount.
Correct, because even if the way it is right now, it's not even reduced to a judgment. If it were reduced to a judgment, at least it would be gaining interest, and he would have some motivation to give her part. But the way it is right now, it's completely open-ended. Now, I need to address in my last few seconds the issue of fees. Mr. Hurley claimed that his client paid my client's fees from her community property. It doesn't work that way. If it did work that way, well then, my client paid his client's fees from her share of the community property. Community property is not that simple, cut and dried, this half is yours and this half is mine. No, it's open. Beyond that, again, I will point the court to the plain language of the statute, which reaches to all financial resources, separate, community, anticipated future. It could presumably even include family resources who could pay. I am out of time. I thank the court for its time. Does the court have any additional questions for me?
I do not. Counsel, let me apologize, though. My iPad tablet went off during your argument. That should not have happened. That's inexcusable on my part, and I apologize for that inconvenience.
Absolutely accept your apology. None necessary, but thank you.
All right.
Thank you.
Thank you, counsel. We appreciate the arguments here this morning. It is likely that we will issue an order shortly on this jurisdictional issue, and suspend the appeal and remand this case to the Superior Court to allow appellant to secure a signed order as it relates to the attorney's fees issue, and then upon the filing of an amended notice of appeal, well, the jurisdiction will revest with this court. We do not need or want additional briefing on the issues, but upon the case revesting with us, we will then at some point issue a written decision addressing the merits of the issues that we've talked about here today. With that, we stand adjourned. Thank you.